and I'm very excited to have Scott Malouf. Scott is a New York-based attorney on the forefront of social media-related rulemaking in the legal industry. Scott advises organizations on social media and tech policies and practices, employee online activities, negative reviews, social media and litigation ethics, background assessment, influencer risks, shadow IT, e-discovery, and more. Scott is a member of the American Bar Association, the BNA Lawyer's Manual on Professional Conduct Editorial Advisory Board. He is also a contributor to the ABA publication Handbook on Global Social Media Laws for Business Lawyers, Chapter 7, Defamation, Discovery of Sources, and Fake News. Scott's contribution to that book focused on social media crisis communications and an attorney's role in social media crisis. We would go on and on about Scott, but let's let him get to his presentation and just end by saying we're lucky he's here with us today, and you should know he's a funny, approachable guy who likes questions, so get yours ready. And with that, I'll hand it over to you, Scott.
Awesome. Greg, if you can let me share my screen, I will start the PowerPoint. And Rhiannon, Allison, Christina, Veritext, Greg, thank you guys. That is, all the work you've done is amazing, and I really appreciate being able to be here. And all right, let's see if it's going to share screen too, and this is going to run properly. All right, you guys see that A-okay? You see the little boy in the title slide?
We do.
Awesome, awesome. By the way, Rhiannon, I'm super jealous. When I go to legal conferences, no one puts that much maker effort and eco effort into it. So you deserve a huge thanks. I have a bunch of maker clients who would be so stoked to know somebody is in the community looking at the things they do. So honestly, that's amazing. I really appreciate it, and I'm sure they would too.
Well, thank you. I hope we can keep it up.
So let's jump right into it, because I already started my timer. So, you know, a big question is, people say, why? Why social media ethics? Why is it important? Isn't it just the old rules and we apply them? And the answer is no. Social is very different. You know, you guys heard the association, Rhiannon, say, hey, send me your what's helping you get through this pandemic, what's helping you keep yourself together. And that's a perfect example what social does well, what it does to add things. So we're going to talk about how social media, how ethics are different, and let's get right to it. And by the way, I do appreciate questions. Put them in the chat. Anyone who's monitoring, Christina, Allison, please feel free to jump in, cut me off, and we'll have this. We've got time at the end for questions, and we also have some flexibility on that. So if we run a little long, we'll still stay in the hour.
Perfect.
Mr. Malouf, if I may, I just wanted to direct attendees to place your questions in the question and answer tab. It should be available to you. The chat is actually disabled, but I just wanted to correct that. Thank you. Sorry.
Oh, perfect. Greg ran with it as usual. Nice work. So let's jump to the next slide. Okay, no worries. I am not going to play the cat lawyer video. We have all seen, everybody in the world seen this thing, right? In the lower right corner, if you're not familiar, that's lawyer Rod Ponton in Texas. And he had a court conference via Zoom. And his assistant said, here, your computer's not working, use my computer. And of course, her daughter had the cat Zoom, the filters on, and he looks so perfectly terrified too, right? We'd all look like that if we were appearing in front of a judge as a cat. This answers the question, why? Why social important? He didn't think he was going to go viral. I mean, the BBC covered this. This went everywhere in the world. And so that's why you want to be prepared and think about these issues, because even if you're like a lot of lawyers, a lot of paralegals who say, I'm not going to use these tools, particularly I'm not going to use them professionally, they may start using you. They may start coming into you. And in this case, I didn't see a lot of coverage of where did this come from? Remember, this is in Texas. In Texas, interestingly, a lot of judges are on Twitter. And so the judge in this case posted the video, and then some lawyers in Texas saw it, they retweeted it, and then the media picked it up from there. So remember, your unique local circumstances, things may be spread in a lot of ways that you, your clients, our organizations don't anticipate. And by the way, the downside also comes in. Some folks came out of the woodwork and started to say, well, what's the background with Ponton? Trying to, even though he didn't want to participate, trying to say, is there anything negative about this fellow? So again, it's another reason to think about the ethics, think about what's coming on. So from the silly, let's go to the incredibly serious and the historical. I'm just going to read this. Every time I read that tweet, it chills me to my core. Okay. And as you can see, this is impeachment manager Ciccolini, a representative from Rhode Island at, I believe, was the first Trump impeachment. Okay. And this is him commenting on one of former President Trump's tweets. And if all of us went back 4 years and said, we know that the president-elect uses Twitter, it's incredibly important to him, would we have jumped forward and said it's going to be evidence, the tweet itself, in a constitutional historic matter? We probably would have said no. But this proves us, again, wrong. And we're seeing that more and more for our own clients. They're not historic matters, they're not constitutional matters. But if you're doing any kind of criminal work, you're doing family law, you're seeing electronic evidence, and a lot of it come in, and a lot of it is social. By the way, a bit of a non sequitur. When I talk about social media, I don't just mean Twitter. I mean looking at things like this, Zoom, because it does have chat functions, and all of these platforms start to take what other people do. So, for example, TikTok is really hot, and Instagram is trying to copy it, but other people tried to copy what Instagram started. So all of these platforms start to meld together. We use them on our personal devices, our work devices, our phones. So that's what I mean by social. So we've had, the silly, we've had the very serious. Now I'm just going to go to the straight gross, which is, if you're not familiar with Jeffrey Toobin, really well-noted lawyer, legal commentator, and he was on a Zoom like this, and he was just, let's just say, didn't go with professional attire. I think this is an important example because we all have Zoom coming into our homes, right? This is virtual. And so a lot of folks are forgetting, you still have to be professional. And I don't mean in an ethical sense, but in the sense of our business, our profession expects it. There are lawyers who've appeared for court conferences next to a pool wearing a swimsuit, and we can go on this. But the point is this tool has changed how we do things. I was on a PLI CLE, and we were talking about, telling staff and lawyers, don't show up in pajamas, right? We would not have had to do that if we were all meeting in person. Now we have to have those discussions, And then, of course, the next thing is marketing, right? TikTok driving new nostalgia economy. So the tools are really useful for marketing, and our clients are doing marketing. Our clients are using these tools for all kinds of things. The makers who we discussed up top, probably every one of them has an Instagram feed to show the amazing stuff they're doing. So this TikTok trend, for example, went to, and it said nostalgia is even wired headphones, right, are great nostalgia. And they're talking about it's nostalgia from the 2000s. Now, if you weren't angry about the Tubin thing, you should be angry about the wired headphones. I got wired headphones on, not because I'm hip and cool and because I'm on this TikTok thing, but because I remember when they came through. So it's funny because it's driving the market. It's important. So even if you don't use TikTok, your clients are using it. But second, there's an evidentiary issue in here. Look at what it says. It says TikTok vloggers are using the small microphone feature on Apple's wired headphones as their symbol for speaking to the audience. So think about that. If you were representing one of those vloggers, and in a case where you said you got paid to be an influencer, but you didn't notify people and you harmed the people you spoke to directly, that icon, that symbol would be a bit of evidence, and it would be harmful to the vlogger. So it's really important as an example of, okay, it's a little different, and know the culture of social, know what's going on. And again, just a reminder, I know it's hard to attend these things. If folks have chat, if folks have questions, use the Q&A function, or otherwise as Greg's directed. So I want to give you guys a lot of tips. My MO usually is to have a ton of tips. We'll have them now, we'll have them later. And so please think of them as things that are really immediately actionable and stuff you can use today. So the first thing we're going to start about is, it may be a little difficult to see this, but it's a skateboarder, and he's got on a face mask and he's got his goggles and his helmet, and it appears to be his toddler strapped on his back, who's similarly goggled and helmeted, right? And behind them is, who I presume is the mom. At least this was taken from my bike cam as I was riding along the canal path, and so I had the whole story in my head. I like to think of it as, if Darth Vader and Tony Hawk connected and had a love child, this guy would be it, right? And the point being, I'm thinking, as I did this story in my head, the mom's like, when I met this guy, is this where I expected we'd be? So take those connections, those unexpected connections, and run with them. Social does this so well. Send me a LinkedIn request, during this program, send it to the organizers and connect on any platforms that feel really useful, and use some of the tools we talk about later, okay, to moderate and manage how you do this. But use social for what it's really good at, because it's ultimately going to help us, help our clients, and move things forward as a profession. Next, I want to talk a little bit about advertising. We don't have a lot of advertising ethics in this program, so this is just a little bit of an homage or a nod to it. If anybody's really excited, for example, the business you're working on, your side gig, your firm has asked you to run it, or your organization, or you're just doing it to search for a position or to advance what you're up to, shoot me a note. Please do contact afterwards with my contact information. We can get a little more information to you about advertising. But I think this is really helpful advice. Number one thing is, whether you're doing it for a firm or for yourself or for a side gig, talk less about yourself, right? If you go to my feeds, I try and talk a lot about cases. And why is that important? A, it works. It generates way more engagement. But B, from an ethics standpoint, by doing that, by not talking about ourselves, not talking about our clients, we avoid some of the biggest ethics risks. We're going to get into them in a minute, but one of the big ones is confidentiality. You're going to see that as lawyers talk about their clients, that's where they get in trouble with confidentiality, with how they're treating the information they get. If you pull that out and you talk about, say, family law when you're a family law lawyer, but not your own cases, you're less likely to get in that trouble. Secondly, humility, authenticity. We don't have, as I said, the advertising stuff in there, but if you look at the advertising rules, okay, you will see they're really about being truthful and not being deceptive. Authenticity, humility encourages that. If you say, do I really do this? Have I done this? Do I have this experience? Yes, yes, for the cases you do. And when no, it's no, you're going to avoid a lot of those ethics issues. By the way, quick note on which ethics rules I'm citing. Unless I specifically say so or the slide says so, I'm using the ABA model rules of ethics. They generally mesh with those in New York, North Carolina, but there are local variations. So those are the rules we're using. Whatever jurisdiction you're in, North Carolina, South Carolina, New York, please do check your local rules, and particularly your local practices, right? Grievances, problems come up because people say what that lawyer did, what that staff member did, what that paralegal did is atypical for what we expect. So be aware of that. And just a quick note on policy. If you do start going forward and doing these things repeatedly, you may want some kind of policy. That's the kind of thing I work on, and then turning that into practices. This is a bit of self-promotion, the Social Media Ethics Guidelines from the New York State Bar Association. I'm co-chair of the committee. And one of our big projects that we're working on now is updating these guidelines. Why are they useful for you? They're useful because of the fact that, one, they're broken down by characteristic, by what you're doing, advertising, communicating with a judge, looking at a jury voir dire and seeing what information is each of those jurors may have. Super helpful. They are keyed off the New York rules of ethics, but again, we cite cases, opinions from around the country, and it's a great place to start. And we'll revisit that a bit. I'm just checking the chat real quick to see if, yep, go ahead.
Scott, it's Rhiannon. I'm wondering, while you're tooting your horn a little bit, toot it some more. Tell us more about how you got to be the social media guy, because you're like a really big dog. I want to make sure people understand that you're fancy. So thanks for being with us today. But really, tell us how you got to be that guy.
Oh, well, I Rhiannon, that's terrible because, it's not going to get better than being called fancy. So I'm going to go back to bed for the rest of the day. I will just say this in all seriousness. My wife and I, we live here in New York. I'm a Rochester boy. We were living in Boston, and the New York State Bar had always been a member, and they were getting started with a social media committee. And I said, guys, I want to, do something. I started running their Twitter feed, and I had been working in Boston on electronic discovery. And so running the Twitter feed, seeing what's going on with Twitter a number of years ago and other social media in early-ish days made me say, wow, this is an opportunity. So I kind of pivoted from e-discovery a little bit and said this social media stuff. And a lot of our lawyers pretty much have said, I don't want any part of this. I don't want any part of social media because it's too much of a problem. There's too many rules. And the ethics rules, the cases didn't support us being engaged with our communities. And so that's kind of how I got involved. It's very base level, just being the guy doing it. And so more and more speaking opportunities came up because people said, hey, I see you're on Twitter. I see you're on LinkedIn. Will you come speak? And then the ethics rules. I don't see myself as an ethics expert by any means. I see myself as somebody who uses social media, who uses a lot of technology and has a litigation background and applies the ethics to them. So, if it's a really deep question, I will reach out to people who I go, you're the ethics expert, but I'm going to use these tools and show people, hey, we can do this, and just sticking our head in the sand and not doing it is not going to be useful. So
you've got a question from Marie in the chat. Do you see it?
I do. Let me jump to it. Thank you. Oh yeah, go ahead.
I think it'll be easier to do that way.
Yeah, Christina, just read them all, cut me off whenever, and I'll leave it to you for the whole thing. Go ahead.
Sure. So the question is, how do you create or use these social media with the caution of cybersecurity protections? Do you have any best practices?
Yeah, I think number one, so we talked a little bit about policies. I think the number one thing you do is you have to say to yourself, what is the characteristic of this information? So for example, if it were medical, any kind of HIPAA related information, banking information, high level client secrets. So you are the biggest and best divorce attorney in your state. So pretty much if somebody walks in the door of your office, folks are interested in that. When you have that really, really sensitive information, I think you have to put a wall up and say, I don't want to put that on social media. I don't want to put that in any kind of cloud or instance that I'm not paying for, that I don't control. I'll give you an example is, one of the NFL players got in quite a bit of trouble because of some domestic issues that came up in a hotel. And the reason that story got leaked was one of the staff at the hotel took a photo or took the video on their personal phone while watching the security feed, and that just walked out the door. The hotel was never able to trace that. And it's because you had that gap versus if someone had used a work computer, they would have been able to do that. So I think the number one thing is knowing the characteristic of your information, 2, setting up policies and following those policies. We follow when people come in, we follow when people come to our website or email us. Same kind of thing with social. How do I move this person who maybe makes an inquiry, or how do I move this data that I'm using from social, or keep it in a controlled way? I think we got another Q&A question. So
yeah, it's just about the link. Well, there's a link in there that I guess isn't working. So
that's my fault. We'll send out a better link. So somebody make a note. We'll send you an updated link. Thank you so much for clicking that and checking. So all right, let's jump to our and please continue to interrupt with questions. It's so much better, and feedback like that to say, hey, Knucklehead, the link's broken. So here's what we're gonna do.
Hey, Scott, we do have one more.
Oh, yeah, absolutely. As soon as I turn away, we get another one.
Yeah, so should a firm have a written social media policy, and what are suggestions for a go-by policy?
Okay, great question. Yes and no. No, in the sense of when you're at early days, okay, let's say the firm says, oh, I wanted to start doing YouTubes, or I want to start doing Instagram, right? Tons of firms want to be on Instagram now, or immigration lawyers, ton of immigration lawyers are using TikTok. When it's small, I am not inclined to start creating policy, not because I think policies are bad, but because I think it's easy to create a policy that doesn't work. So for example, one of the things we were doing with the Twitter feed was at one point we had to post something for the bar. We must have had about 15 or 20 emails going back and forth. And you're never going to be able to run a feed if you got to have 15 emails for each post? So the answer is early days, no. As you get bigger, or if your firm is bigger, or if you have more sensitive matters, again, that divorce, or you handle huge Fortune 500 clients, or you have clients who in the engagement letter may have certain restrictions on how you use information. In that case, you what you want to do is then you do have a policy. But I'm of the school that says have a shorter policy, like a 1 or 2 pager with examples, and then you're going to have education of folks who are running the feed, and then revisit like every 3 months. Excuse me, you want to revisit. And the example I give is running a Twitter feed. It's pretty, it can have video, but often it's pretty text-based versus running a TikTok feed, which is all video, which is music, really different kinds of rules. So that's how I would handle that. So let's jump into the discussion points for today. And please do keep the questions coming. Please do interrupt whenever we see a question coming. So we'll jump in. And if we run a little long, the misconduct one, we'll just skim over because that's very much a specific case. So competence, competence, competence. This really is the duty that most people, that controls all other, right? It's the ring that rules all others. You have a Lord of the Rings reference. And what you see here is Rule of Professional Conduct 1.1, comment 8. And I'm just going to read the relevant parts here. It says, a lawyer, you got to maintain the requisite skill and knowledge. You've got to stay abreast of changes in law and practice, including the benefits and risks associated with the relevant technology. Okay, so what does that mean? It means to me 2 things. One, if you're going to use a technology, particularly a social media technology, know how it works. Okay, if something on Facebook goes out to the whole world and you only intended it to go to the people who you're friends with, then you should know how that works. If you tag somebody else, then it's going to go to their friends as well. You should know how that works. So that's one of the big ones. And 2, know how things work for our clients. One of the things, one of my tips later is talking about you guys and your hands-on with the data. When you're talking to the clients, ask them what platforms you're on, what technology to use. The simplest question is just to say, what are the 2 or 3 most important apps or programs or activities you're involved in? Is it email? Is it Discord? Is it video? Is it texting? No matter the size of your client, whether it's just a one person or it's a giant company, it's a great question, because then even though you may not use something, you may not use their specialized platform, you now know that's where I need to look. I might want to become a little familiar with it. So it's really helpful there. Another example is settings. Okay, this is a great case, comes out of my neck of the woods, a matter of Catherine Nugent Penapinto. So it's a Buffalo judge. So she had a family matter. She was involved in a public dispute over an educational issue because she had, I believe it was her daughter was in a public school. And so the judge had done a bunch of things, but the thing we want to focus on is the judge had been involved in commenting on a newspaper story that had been posted to Facebook. And the judge commented, and Facebook automatically identified her as, you can see here, Catherine Nugent Penapinto, works at elected New York State Supreme Court judge, November 2010. So she did not, at the time of commenting on the post, type that in, that she's a judge. She did not do anything other than just make the typical comment. What happens to her? She did eventually agree to a sanction, a violation of the ethical rules for judges. And what did the New York State Judicial Commission find? Our Commission on Judicial Conduct. Respondent avers she did not know that Facebook settings would automatically identify her by her judicial title. She concedes that she should have familiarized herself with Facebook protocols prior to posting. So the big point there is, years ago, presumably, somebody typed into that field, elected New York State Supreme Court judge, and then settings were set such that when a comment was made, it wasn't anonymous. The comment was made under the real name, and it pulled down that data from fields already entered. And that's what got her in trouble. And the court said, it's no excuse that you didn't know how it didn't work. And I think that's very much true for us as lawyers, as paralegals, that you have to know how they work, and you may get in trouble. So we want to be aware of those things. By the way, settings is kind of a funky issue. We're going to talk a little bit more about that downstream. Second, confidential information. This is kind of the big whale. And I'm sorry, guys, I keep having interruptions come in. I didn't mute my phone.
Oh, don't worry about it. That's just part of our modern Zoom world.
Yeah, well, so that's a perfect example, right? I'm telling you settings. Did I put my phone on airplane mode? No. So confidential client information. So after confidential information is really important. And many people have not really gotten a good definition of what confidential information is. So again, it is information relating to the representation. And this is under ABA Model Rule 1.6, which defines confidences. It could be the client location, client financial information, messages to and from the client. We get that. But it can also be a public document or record. So I cite to an ABA formal ethics opinion there. You may want to take a look at it. So for example, in South Carolina, a lawyer had, and I see there's a question, we'll jump to it in a second. A lawyer had a really great case and wanted to promote it and say, look, what a great job I did. The Bar Association, in furtherance of stuff like that, went to the high court and said, look, we'd like a statement from the court that if a case is a public case, so it's been litigated, there's a public record of the results, the lawyer can promote him or herself by saying, here's the public case. The court came back and said, no, it's actually the opposite. You need client consent to do that. So think about that. That case is available to everybody in the world. It's on Google Scholar, it's on all of our services. Yet the lawyer who was involved can't do it without client consent, yet it's completely public. That's how that rule works. Let's take a quick look at the question. Do you guys want to read it? Christina, you want to take that?
I'll read it. Yeah, so this is about MS Teams meeting sites. They may not be a part of your presentation, but recently I attended an MS Teams meeting where personally identifiable information was shared about a client. I suggested we not share full names, socials, etc. on Teams, and the reply was, all of our employees take confidentiality training. The fact that MS Teams may not have a confidentiality agreement seemed to go right over their heads. Do you have any suggestions on how to handle this?
Oh, awesome. Okay. First of all, thank you for that great question. I love that. And this kind of goes back to the question that we had about policy. And what I'd say is, first of all, if something's recorded, now that recording, right, has Social Security number, has information that certain laws may apply to, and we may have to tackle. And now, has anyone given provision to the idea of, we got to go back and review that? I mean, video records are a ton of work to review. So I think your point is really well taken. Secondly, that's why process and thinking about these things are so important. Okay, if we're going to share information like that, can we redact it before we get started? Can we make redaction part of this? I mean, you've seen some of the courts have difficulties with older records where people were just willy-nilly filing Social Security numbers and things like that. And it went all the way through, and the courts are now trying to redact those. That's a lesson for us in our same level. What we really need to do is think of the information as information, know it can be shared in multiple formats: audio recording, video recording, internal messages. Somebody could just text it, hey, I need that social. Okay, I'm going to text it to you, 2 personal phones. Instead, saying we got to have a better process for it and know this. Because if anything leaks out, if you have inadvertency sharing of data, even if you just transmit it to the other side, you may have caused a problem. So that's a really good question. And again, that may fall under confidences, that may fall under particular court rules, depending on what court you're in. That may fall under federal statute or state statute about handling this kind of data. Sometimes as lawyers, we forget some of those statutes may also apply to us. Okay, so we know what confidential information is. It's relating to the representation. We can't reveal it. So we can't reveal it without, unless we have client-informed consent. It's impliedly authorized. So for some reason we can do that. Or there's a disclosure permitted by lower level of the rule. So you'll see that. So it's really broad. It's much broader than attorney-client privilege or work product doctrine. But those 3 kind of all work together to shield and protect information. And we're going to go through them down below, because I think that will really help you see more about where we are. And I'm just checking the time that we're at. So negative reviews. I think negative reviews are a great place. And if any of you have, your lawyer tasks you with, hey, respond to that review, go back and check this slide. Go look at the guidelines, because it's a great example of confidentiality in practice online. So if you have a client and the client puts up all the details of the case and the client is saying, gosh, what a bunch of terrible lawyers, you really don't have that much flexibility to respond, okay? And it's because of that ethics opinion I cite in there, 496, okay? Because the client didn't waive that confidentiality. That information is still related to the representation. You need their permission, to reveal. And so two things. One, do you think they're going to give you their permission? They're upset with you. And two, the Pennsylvania Bar Association, I've got some language in there. That's the language that they recommend. This is a great example of process. Hey, if we're going to respond to reviews, this is the kind of language we use. And I mentioned proactive steps. Really, negative reviews are going to come in. And so what you try and do is you try and get those positive reviews beforehand. You try and have that positive social media before, so you don't get into that kind of trouble. Former clients and reviews, a little bit different rule. So confidentiality is 1.6. Reviews, former clients, their confidentiality is 1.9. And the language says that basically former clients, you can't use the information to disadvantage a former client unless it's generally known. So, the other case we saw 1.6, that may be generally known. It went up to the high court of the state, but it doesn't fit. So 1.9 says, okay, maybe there's a little more breadth, a little more room, and you can't reveal any information related to representation. That's pretty similar. So here's a case that I think explains it. It's the matter of Brian LeBron Calpin out of New Jersey from last year. And I love this case. I'm laughing because I do like it. The lawyer decides to review the client. So the lawyer gets a negative review from a client who's a masseuse. And in his defense, when he got in trouble for this, the lawyer said, well, this is good for what's good for the goose is good for the gander. So he went on, and I'm going to read this because I do like this. He said, she is, quote, a convicted felon for fleeing the state with children, a wonderful parent. This is obviously my intonation. Additionally, she has been convicted of shoplifting from a supermarket, hide your wallets during a massage. Oops, almost forgot about the DWI conviction, and that's kind of the relevant part. So those are public records. Those are convictions. It's very clear, it's out there in the public. Did that fit generally known? And the opinion, the court said, no. Yep, it's public information. They're court records, but it doesn't fall into generally known. And he got a 1-year suspension. Now, mind you, this is a situation where he had other issues, not just the social media post. We're going to talk about social only down below. But let's go back to that step where I say very little flexibility to respond. If you're responding to a negative review, if you're trying to share confidential information, I think you can see from what I've said and from that example, you're really trying to check kind of a few very narrow, exceptions, or you're trying to kind of wind away through the stream. It's not a strong thing to do. So don't put yourself in that position. And by the way, we talked about online is different. Do you think a person who's posted a negative review, a person who's combating you publicly, maybe it's not a client, is going to say, oh, old bean, you're right. I shouldn't have posted that terrible review. I don't know why they did the terrible British accent, forgive me. But they're not going to do that. They're going to double down. They're going to triple down. The platform is going to see that the person or that this post is generating engagement. So it may lift it up. So that's why we don't want to do those kind of things. We want to say, let's take this in stride. If most of our clients come from word of mouth, maybe we're not responding in that way, or maybe we engage different ways to do this. Call somebody like me to say, okay, what are some of the things we can do to build up the responses to that? A little bit different rule. So we're moving away from confidentiality. We're moving away from former clients. This is North Carolina's version, very similar to the ABA, I believe, of respect for the rights of third persons. Okay. And so you can see what this talks about is when you're involved in any kind of, legal effort. And a lot of these rules are written towards litigation, but don't just interpret them that way. You could be involved in an M&A situation. You could be involved in a family matter, trust and estates, thinking about digital assets. If you're representing a client, you cannot use means that have no purpose other than to embarrass, delay, or burden a third person. So how does that play out in social media? Here's a case from my neck of the woods. Okay, this just came down October 8th. So a couple of weeks ago, it's the matter of Salvatore Lanza. So Attorney Lanza was involved in a family court matter. And he had been engaged by one of the parents who didn't have custody to reach out and get supervised custody or supervised visitation by the other parent. What had happened was the other parent, who was out of state, had allowed a minor child to be supervised by an 18-year-old. That 18-year-old sexually assaulted the minor child. And so that generated the litigation where the parent here in New York said there needs to be supervised visitation. So that's where the case was. Lanza was pursuing that. And after having, I believe it was a court hearing or being engaged, he takes the information and publishes it. And it wasn't clear from the opinion what platform it was published on. And it lists that it's the home state of the victim, of the young under 18-year-old, the age and gender of the victim, and the youthful offender. Now, that's what we have. So it's a very short opinion, it's only about a page and a half. Take a step back. Lanza practiced in a small town, and it was a family law matter. People, quote unquote, as the opinion says, knew who he represented. And so moving forward, small town, people knew who he represented. They would know, despite the fact of not using names, by the ages, by the situation, who he was talking about, both with the client's child and with possibly the youthful offender. And so what you want to do is stop. And the big takeaway, the picture here is, and you're going to see this comes up a lot in family law matters, the tools we've traditionally used to anonymize, right? We don't mention names. We don't mention particular really unique elements. They may not work on social media because the record is created, somebody may see it, and it may be sent to the client or sent to other people or seen by other people who have that knowledge. So a lot of our traditional tools that we use, anonymizing, don't work, or at least are less likely to work on social media. So that's why we got to be prepared for that. So taking a step back to Lanza, it was the family law case. He posted only one day. It came down because opposing counsel had said something briefly. And again, it was without names, but it was ages, genders, and he's a small town lawyer. The court said, look, in an agreed censure, you have violated 4.4. This is a method that harasses and harms other parties, and it's conduct prejudicial to the administration of justice. And we'll see a little more prejudicial to the administration of justice, but in a lot of ways, that's a catch-all. If the court has to rule on something, if the court has to change its procedures because of things you're doing on social, there's a case out of Florida where a lawyer was making some quasi-threatening posts, and the court felt like it had to intervene. It was a motion was brought, court had to intervene and import new rules, having deputies around for depositions. That's prejudicial to the administration of justice. So anytime you're sand in the cogs, that's what it is. So here, Lanza had a clean record, 35 years of practice, and he just agreed to a censure, okay? And so that comes out. And by the way, we've been discussing attorneys. I needed to mention a moment ago, this is not throwing aspersions at any of the lawyers that we talk about. We don't know what all the individual facts are. As I mentioned in this case, I only have a page and a half decision. I don't have the backstory. I don't know all the other things that went on. So please don't take anything away other than maybe like a little bit of the lesson I mentioned. And no, these are educational. All the lawyers are moving forward. We're moving forward. So don't look at any of them and say, okay, this is what I think about a particular party. This is some education, and this is what we can learn, because we only have a real small snippet of what went on. So next, attorney-client privilege versus work product. I mentioned these because as you are handling data, confidentiality, work product, attorney-client privilege may be required of you and keep you from sending data out. So somebody requests data, somebody is requesting data from you, and you can use these tools to not provide that data to others because that's the appropriate method. Or it's also for you to think about, what am I posting? Like we had that question about social security numbers, and to say, are any of these kinds of doctrines implicated? And the reason is because any of these doctrines, we can waive them, we can breach them by oversharing. And of course, we all know social media is very good at oversharing. So what's attorney-client privilege, right? A lot of people don't understand this. I go over this. A lot of attorneys don't get this because you get it once and then you don't really use it. It's common law doctrine. It's just the idea is it protects communications with a lawyer and encourages the client to tell us anything. Whenever I engage with a client first, I always say, look, you can tell me anything. I'm not going to be compelled to give it to somebody else. Work product is very different. All of us are now seeing huge files, right? Even if it's just a criminal matter. And again, that's not besmirching criminal, but one individual, a cell phone collection can have, terabytes of data on it in a felony case, right? 20 years ago, that wouldn't have been the case. Maybe you get a couple of banker's boxes. So work product is the idea that it's a-okay, and we want to encourage people to take notes during litigation, to prepare for litigation. And so they both protect things, but they protect things for different reasons and in different ways. And here's a useful chart. If you want to take this away, this is a really good thing to use in the future as you go forward. If you want to assert attorney-client privilege, an attorney must be involved, or you're part of the staff working with the attorney for delivery of legal advice. And it requires a communication to generate or to collect legal information. So sometimes you hear stories about people going, oh, I forwarded that to my lawyer, so I don't have to turn it over. Unless you forwarded that communication in order to get legal advice, it is not protected, but it's not likely not protected by attorney-client privilege. It's, oh, hey, I forwarded this contract, Scott. What do you think? Should I sign it? That would be protected. Okay. Is litigation required? No, it could be any matter. Hey, I want to do something with my will. Can an adversary's need overcome? No. It's completely protected. The adversary can say, I really, really, really want it. They don't. Can you waive it? Yes. Work product, different creature. Does an attorney have to be involved? No. A company can say, I anticipate litigation. We're going to start collecting information. Maybe we generate a memo about that. Do you have to have a communication between the lawyer and client? No. Must the communication relate to legal advice? Again, in work product, no. It's a litigation preparation tool. It's a rule in the federal rules of civil procedure, the North Carolina rules of civil procedure, and it's going to protect you. Is litigation required? Yes. So work product is, we thought a case was going, a case is ongoing. And then can your adversaries need overcome it? Yes, there are times that happens. By the way, same thing with the ethics rules. If you're relying on these, if you're in state court, you're in federal court, look at the local cases, look at the local practice to see what it is. And of course, both are waivable. So this is the tips section. It kind of summarizes what we've done. And again, if folks are seeing questions, please jump up and cut me off. So what are your tips? Number one thing is you guys are eyes on the data. I mean, early on, explain to the attorney, to the e-discovery folks, to whomever is making kind of those top line decisions, what's in there. I mean, one of the most common problems I see is people will agree to do stuff and they won't look at a sample of the data, right? And so I put up this stat about Facebook. The average Facebook user's got a couple hundred, almost 300 photos, 53 links to images. So as any typical matter rolls forward, whether it's a litigation matter, right, or it's an M&A where you're trying to understand digital assets, or it's any kind of employment matter where you're trying to advise, that pool of data just gets bigger. It rarely gets smaller. Oh, we've got to look at more employees. Oh, here are five or six more sets of digital assets, either online or personal. So one of the biggest things you guys can do is really kind of go through and sample. And as new tranches of data, new types of data. So what do I mean by types? Videos, social media accounts, other things. As those things come in, just take a quick peek at what's in there and know, when's this a problem? And what do I mean is, how many clicks are you doing? If I had 300 text files or 300 videos, those text files, right? We can probably word search it. We may have an e-discovery platform that's really good at looking through those. We can slice and dice by metadata. Those videos, I still have the metadata available, but what was said in the video, now I got to go to an outside vendor and see if they can collect it. And, heaven forfend, it was video taken on the street during windy days. And so the recognition rate is in the 90s. We're probably going to miss a lot of stuff. And do this early. I can't stress enough, too often people go down the path, we're all busy, and then it's not done early. And then you're 3 weeks, a month in, the deadline is looming, and we haven't gotten that done. Keep up with how people use tech and ethics opinions. And I make that point about, and I got the TikTok throwback thing there, the early 2000s. There's just a case out of New Jersey where the case started an ethics opinion. I think it's Robert Telly is the name. Started in 2008, and the court just issued an opinion. And it's an ethics opinion about, I believe it was Facebook friending. And one of the big points the court made was, back in 2008, we had different attitudes about this. We had different levels of knowledge about this. We had different understanding. But now much time has passed. So don't take our decision. And I believe the attorney did not get in trouble in that decision. Don't take that as now fact, because it's 2021 and there are different attitudes prevailing. I think if 5 years ago we talked about fake friending, a lot of people would have said, oh, I got a different bunch of opinions. Now we'd say, for the most part, don't ever do that, because most likely it's going to violate a rule. I mentioned being personal and humble in posts. Again, same thing for the organization. Just take a step back. I know your phone's there, our phones are all there, but if you say to yourself, am I executing on those values, it's probably going to save a lot of grief. Confidentiality still applies to your personal accounts. A lot of lawyers have gotten in trouble for posts on their personal accounts, didn't even identify them as lawyers, or may have identified them as a lawyer, but completely personal use. And if anybody has questions, please do chime in, hit the questions in the Q&A function, and I'm happy to address them. And again, we'll have a little bit of time at the end. More tips. The attorney is ultimately responsible for the matters for supervision of everyone working on it. I'm not addressing it. I know you've got a speaker coming later who I assume is going to take care of that. For social media, though, I think this is really an important point, because it plays out, again, a little differently. So as I say, the directions can be unclear when applied to social media. And I referenced the I Heart Hot Moms case. So officially, that's known as Allied Concrete. It was an injury type case, and unfortunately, a man's wife passed away related to the defendant's activities. Settled for quite a bunch of money, but in the pendency of the case, the lawyer got notification somehow that the claimant, who is grieving, had a T-shirt on that said "I Heart Hot Moms," and I believe he was partying on a boat. The lawyer says to the paralegal, "Clean that up." What does that mean? Clean that up. That's what I mean by the directions are unclear. Did he mean go change the settings and talk to the client and take that information and make that less publicly available in a search? Okay, that's acceptable. There can be some debate, right? This is back to the Judge Penapinto. There can be some debate about that. I think for the most part, North Carolina has issued an ethics opinion, I want to say a few years back, that said, nope, changing settings is fine because we're not deleting data and we're not making anything disappear, assuming the underlying demand is for just the posts, not for any kind of settings data. So that's fine. Some people say, oh, you can't change settings, but I think that to me is a minority opinion. So was that what the lawyer is saying? Go clean that up. Was it change the settings, which would be fine? Or did the lawyer mean go delete the data, which most likely would not be fine, would not be ethical, would not be comply with the discovery rules? And moving that forward, the lawyer's the one who lost his license. I believe he paid a $500,000 fine, and I believe he retired, right? So one of the things you guys can do is point to this and say, wait a minute, when I have to execute on this stuff, what exactly do you mean? And I think by slowing down, that gives us more of a chance to introduce ethics and introduce what should we really be doing here. If changing the settings, was there, and then you didn't disclose that information properly in discovery, you can get the same result without engaging in conduct that's questionable. Secondly, use the guidelines. I mentioned that. I mentioned how they're organized. I mentioned the sites and links. If you were trying to push back on people, like that question we got where people said, oh, everybody signed something, point to those guidelines and say, wait a minute, other people have dealt with this issue. Other people have gotten into it. And it's something you can hand the lawyers. We're updating those, and you can say, check through these. Because I think as you personalize that and you make people understand that, it creates a better understanding of the risks. PowerPoints like this and other presentations make people better understand where those risks are. Again, just the point about confidentiality, work product, they all work together, but they're a little bit different. And just a super practical tip, if you're repping a client on personal matters, and they're using their work or email accounts, work email, work Slack, work devices, get them off that and just say, look, I really want to communicate with you on a personal level. I don't see any questions, so I'll keep going. So those are all the tips. The final section we're going to talk about here is misconduct, okay? And misconduct is kind of the catch-all rule for the lawyers. And it's about attempting to violate the rules. There's a number of subsections, but the two we're interested here are attempting to violate rules and engaging conduct that's prejudicial to the administration of justice. And the case I'm going to talk about in a minute is a perfect demonstration of that. I see we've got a question. You guys want to jump in and hit that?
Yes. So when you say changing the settings, do you mean making it private as opposed to deleting? In other words, if you remove it from public view but preserve the information, are you okay if you are still willing to produce it pursuant to a Rule 34 request?
A, fantastic question. And B, I love the fact you're parsing it out because that's exactly what we should be doing. To me, when I say that, what I mean is we start where you started. A request for discovery. What is discoverable, right? I don't have some kind of general fleet overall, generally. I don't have some free-floating obligation to produce things. I need you to request things of me. There needs to be a court rule that says produce these things. There needs to be a common set of practices and understanding. Something has to generate that request, okay? So once we have that, right, you want me to produce images post-accident of this person, you know, showing them and their physical condition, or if we allege some kind of mental injury, you want me to produce images and posts showing this, okay? So now I have an idea of what we're doing. You didn't ask me for settings information. You didn't ask me for when the account was created. You didn't ask me for IP addresses or what kind of devices they're using, okay? So that's the first part. And secondly, what I do mean is, yes, you can change the settings. And again, look at the ethics opinions, look at the guidelines, because every case is factually driven, to say, okay, I am going to keep this information. I'm going to keep the underlying post. I'm going to keep the text. Maybe I've made some slight changes to settings or to my record. You know, this was public, now it's private. Sometimes could be relevant, but let's assume it's not in our case. And the data is still there. I'm then going to extract that data in whatever process I use. Maybe I use a vendor, maybe I download it, maybe I do a Camtasia, something. I'm going to extract that, and then I'm going to produce that in discovery. That's what I'm talking about, is the information was publicly available. Anybody could find it. We changed it. We made it private. We then pulled down a specifically defined set of information, and we produced that in some format in discovery, as opposed to there are certain articles out there where people say you can't ever change the settings. Once it's public, it's public. I don't agree with that. I don't think it's a good bit of advice. So that's what I'm talking about. Thank you for the question. If that didn't answer it, ask another question or send me a message online and we'll do that. So misconduct is what we're talking about. As we were defining it, it's basically kind of the catch-all. You can't attempt to violate the rules. You can't violate the rules. You can't prejudice the administration of justice, put a burden on the court. This is a case that's really interesting, came out of Tennessee early this year. And it's kind of unique because it's one of the new breed of cases that only bad acts are on social media. In this case, and the names will be important, so I'm going to slow down here. There's a woman named Lauren Houston. The attorney is named Sitton. They had not met, as far as I can tell from the case. Ms. Houston is in a matter or in a situation where she's alleging abuse, and harassment by Henderson. He is the father of her child. She is posting about it on Facebook. Unprompted, Sitton responds to her posts about the situation, about the parenting, about the child. Henderson eventually, kind of through a string of things, becomes aware of this, and the Tennessee Board of Professional Responsibility is alerted. So this is a really good example of kind of how these things shake out. How does a post then become something that somebody gets notice of and then becomes a grievance, an ethics complaint? What was posted? I think the language in all these cases is really important. And again, I'm going to read this. You can check it at your leisure, but I'm going to hit you with the highlights. Houston writes, quote, "I need to always carry my gun with me now, don't I? Is it legal to carry in Tennessee in your car?" Sitton responds, "I have a carry permit, Lauren. The problem is if you pull your gun, you must use it. And then he kind of goes on to talk about how he's afraid of the situation. It's better to use a taser. Here's my shotgun. The italicized parts are mine. And this is the key that Sitton says. If you want to kill him, Henderson, lure him into your home and claim he broke in with the intent to do you bodily harm and that you feared for your life. Even with the new stand your ground law, the castle doctrine is far safer for the use of deadly force. So Sitton is telling her how to achieve this crime, how to harm Henderson. She responds, I wish you would try. Sitton then goes on and doubles down. Quote, again, my emphasis, as a lawyer, I advise you to keep mum about this if you are remotely serious. Delete this thread and keep quiet. And then he goes on to talk about, what the defense and how it works. And a third party, somebody else, so I have no idea who this is, says he, Henderson, the father of the child, he's likely already seen this thread, which was in fact true. So what happens? Because I believe Henderson eventually grieves Sitton. And so what happens to Sitton? So the Tennessee board alleges a violation by Sitton. And they said, wait a minute, you counseled Houston, the mom, on how to engage in criminal conduct, and you gave her a manner that would minimize the likelihood of conviction. So she had ill intent for all intents and purposes. She wanted to commit a crime, but you've helped her stage this in such a way that it makes it more difficult. And of course, you then went on to say you're going to delete the evidence. A number of ethics violations they allege, they start to fall away. And the hearing panel finds A and D. Okay, so violate the rule. You've attempted to violate the rule. You're not supposed to give people advice on how to commit crimes. And you've prejudiced justice because you're suggesting delete it. 60-day suspension. In Tennessee, the process is for the high court to take a look at this. So this is then goes to the Tennessee High Court. This is what they held. They said, look, Sitton, you offered specific legal advice on how to orchestrate a killing, their language, orchestrate a killing in a way calculated to provide the perpetrator a fabricated defense. So again, they really come down hard, and they don't say, oh, you had this offhand Facebook exchange. They say you're providing advice. And then you made an attempt to conceal it, i.e., let's delete this thread. The acts are violations of A and D, D being prejudice and A being, attempting to violate the rules. And the court goes on to say two interesting things. One, even if you gave this advice at a cocktail party, you gave this advice over lunch, it would still violate the rules. So the social media side doesn't change the substantive analysis, but the social media is an aggravating factor. The court uses the language where they say this usage is like using live ammunition. And the big takeaway is his 60-day suspension becomes a 4-year suspension. So huge punch for him. If we have questions, we can get to them now, or I can give you guys a couple of thoughts on where we're going. What would we like to do? We have any questions we want to open it up to?
Scott, I don't see any questions in the Q&A right now.
Okay. All right.
Unless anybody pops up with another one, I am really interested in what your forecast for social media discovery is.
Okay, that sounds good. That fits nicely with this, and that'll keep us right on time. So posts and punishments. I mean, I think our big thing is we're going to see more ethics where it's just the social media use. And the examples I give right there, Sitton, Lanza. You don't have it in your materials, but Frank Arthur Smith, similar to a Lanza kind of post. And the public nature of these posts, right? The very thing we want, share with the world, connect with the world. How are you surviving the pandemic, right? That very thing is also the thing that makes it much worse. As the court says here, his decision to publish the comments on a public forum made his situation exponentially worse. All right, I think we got somebody we got to mute for a second. But
yeah, somebody has to mute, thanks.
No worries, right? It's Zoom. This is how we go. All right, so last thing, this is really interesting. So here's a tweet from John Della Volpe, and he's a researcher over at Harvard. And I mention this because this is one of the big takeaways for you guys is this stuff is sticky. It's addictive. And as you can see, you don't necessarily need to look at his polling here, but the polling says, it's similar. Look at his tweet on the right-hand side. Nearly 2/3 of Americans who use the platforms believe life was better without them, right? That was that whole TikTok trend from Axios up top. Life was so much easier in the early 2000s without these. But 42% of Gen Z are addicted and they can't stop. So everything I've advised you, you have to understand with clients, they're going to still do it and we have to prepare for it. And the last thing I want to leave you with is, this is from Bradshaw Sitton. He was directed to have 9 hours of CLE focused on ethical use of social media by attorneys. You guys have had one, you're 8 hours ahead. So it's all good. So that's all I got, and we're right about at time. So if anybody has questions, you can ask online or you can hit me up later. I'm happy to do it.